Hi guys. Uh, I found another article that I'd like to share with you. Uh, I enjoyed the comments from the last article from this same uh, whatever blog or research group or whatever they want to call it. I haven't. I should have. I always start my videos and I just go right into them. I don't do a lot of planning. I should do more of that, huh? Anyway, I'll share it with you, and I enjoyed reading everyone's comments and stuff afterwards. And I hope you guys enjoy this one as well. I thought it was very informative and had a lot of good information in it. So let's get into it. This is pretty much the same as the last article, the little header there. We'll skip that. And let's dive right into it. Over the past decade, a growing number of cities, counties, and states have recognized the profound injustice of the cash bail system, in which people who can afford bail walk free while those who can't are detained. But that awareness gives rise to a thorny question. What should replace it? How should judges decide whom to detain pre-tail? In many cases, the answer has been to rely more heavily on risk assessment, algorithmic tools based on a predictive analytics. Not only are risk assessments used by judges in pre-tail decisions, but they are also being used to consider for use in sentencing and parole decisions. Nearly every U.S. state and the federal system have implemented risk assessment in some form. Several states are at various stages of rolling out new tools, and the recently enacted First Step Act mandates the development of a new federal risk assessment meant to reduce recidivism and connect incarcerated people with services any corner of criminal law, yet unchanged by predictive models, will most likely not remain so for much longer. It is easy to see for the appeal of risk assessment. The decisions that judges and other justice system actors make daily can be hugely consequential, not just for public safety, but for the lives of the accused and crime victims, as well as their families and communities. And yet, unconstrained judicial discretion can be dangerous if judges are biased against a defendant or a type of defendant, for example. If risk assessment can make those decisions even somewhat easier and do so in a rigorous, evidence-based manner, leading to a fair and more just outcomes, then they would be an unalloyed good. Propotenness of the algorithms say that imposing some mathematical regularity will lead to the greater transparency and accountability, and ultimately to improve on the current system. But the reality of risk assessment algorithms is more complicated. Critics say bias can creep into every stage, from development to implementation to application. Often that's racial bias, but other characteristics such as age, ethnicity may also drive inadequates. These purportedly objective algorithms are developed by humans using imperfect data and are enmeshed in fraught political questions. They are also often used in situations beyond their stated intents. Risk assessments developed to measure whether someone will return to the court are sometimes erroneously used to measure that person's risk or offense, for example. Despite the talismanic manner in which people deploy the word algorithm, nearly every aspect of such decision making is ultimately dependent on human ingenuity or lack of, therefore. Since the age of the algorithmic risk assessment is underway, the question is not whether to use those tools, but how to do so in a way that maximizes fairness and minimizes harm. Even some observers who are wary of bias seem promised in the use of risk assessment to inform treatment decisions and provide access to resources based on incarceration, or besides incarceration, The explainer will help make sense of some of the basic technical aspects of these tools, as well as the state of play with regard to the controversies that dominate the field. What does it mean for a risk assessment tool to be algorithmic? Risk assessments have been a part of the United States criminal legal system since at least the 1930s, but for decades they were clinical, meaning that they relied primarily on expert judgment. Those experts may have been psychologists, social workers, probation officers, or other justice system actors. But the assessment hinged on the judgment of the person conducting it. In constraint, actual risk assessment are based on statistical models and ostensibly do not rely on human judgment. Such models could be as straightforward as linear or logistic regression models, like you may have learned in an introductory statistics class, or could involve modern machine learning techniques. Algorithmic risk assessments then are just a kind of actuarial risk assessment. The term is typically used to refer to risk assessments where the computer performs a series of steps to provide the ultimate risk scoring. Despite the talismanic manner in which people deploy the word algorithmic, nearly every aspect of such decision making is ultimately dependent on human ingenuity or lack of, therefore. Algorithms are designed by humans, run on computers that humans built, trained on data that humans collected, and evaluated based on how well they reflect human priorities and values. Despite the utility of this approach, one theme that recurs in studies of algorithmic justice is how thoroughly human flaws pervade ostensibly objective mechanical process. How do risk assessment algorithms work? Most risk assessment tools combine court and demographic records with some sort of questionnaire administered by the court official, such as a pretrial service officer in a bail context, or a prison social worker in a parole determination. Some tools, such as public safety assessment, created by the Arnold Foundation, now known as Arnold Ventures, omit the questionnaire and use only the statistic data. The tools consider such things as criminal history, job status, level of education, and family information, giving each a numerical weight that makes the factor more or less important in the calculation of the final score. The idea of weights in the model bears special emphasis because in many cases that is the least transparent part of the algorithm. Although some creators of risk assessments share details for their models with the public. Other models are developed in private companies that keep the inner workings of the algorithm secret. Even for some of the most locked down proprietary tools, the questionnaires that practitioners used to administer them are freely available, as are training manuals. The Arnold Foundation's public safety assessment uses these factors, which are generally representative of the field. And here's a chart, and I'll be posting a link of this in the description below. So let's not spend a lot of time going over this chart. That's for you to go over yourself and see what you think about it and get a better understanding. The process of setting the weights is known as training the model. In the machine learning context, this is known as supervised learning. A data set is fed into the model that contains a set of features such as age, number of prior arrests, etc., and as a set of known values for the outcome variable the model is supposed to predict. For instance, if the model is supposed to predict likelihood of rearrest within 2 years, as it is in many risk assessment tools, the data used to train the model would have a big data set formatted such like a spreadsheet that associated values of the input variables with a value for the output variable, i.e. prediction. The input used to train the simple model using just the age and number of the prior arrest used to predict the rearrest might look like this. Here's a little chart there. A real data set would be much bigger, have many more variables, but here the process of setting the weights for this simple model would just involve figuring out how important age is in conjunction with the number of prior arrests in predicting the likelihood of a given outcome, rearrest within 2 years or not. Once the developer has established that these weights, and ideally after a great deal of testing, the model could be applied to new data. Algorithmic data, human priorities. Even the basic model described above, with 2 features and 1 output, introduced 2 of the most continuous issues with algorithmic risk assessment, namely the choice of inputs and the quality of the data. The choice of the inputs reflects both what the tool developers aim to predict as well as the data they believe will make those predictions accurate. Similarly, the quality of the data that goes into the model reflects the priorities of the people who collect the data, i.e., what they choose to capture. But there is often a mismatch between the outcome of a risk assessment is meant to predict and the data used to train the predictive model. And this gap is largely due to the nature of the available data. Data about arrest and convictions are abundant, making it an attractive choice for tool developers. However, arrest data show more about the behavior of the law enforcement and courts than about the individuals to whom the tools are applied. A risk assessment that is used to inform a sentencing decision ought to predict whether the person being sentenced is going to commit a new crime at the same point after the end of a period of supervision, and that decisions should be based on whether people with similar profiles went on to commit crimes in the past. But while estimated data about such activities are available, those estimates are incomplete. Many developers of risk assessment tools, such as the makers of Compass, it's COMPAS, I don't know why I said that. You all can see it just as well as I can. Used rearrest within 2 years as a definition of recidivism. As such, the models these developers build will be based on data containing just this statistic. But ideally, a tool designed to inform sentencing decision ought to be predicted in the likelihood that the person being sentenced will commit a new crime, not that the person will be rearrested again. Many crimes occur for which no one is arrested. And of course, people who routinely rearrest without having committed a crime, the likelihood that someone will be arrested has to be at least as much to do with policing. Which often disproportionately targets low-income communities of color as much as it does with the behavior of the person getting sentenced. This has been particularly problematic in Philadelphia. Bradley Bridge, an attorney from the Defender Association of Philadelphia, told the Marshall Project, this is a compounding problem. Once they've been arrested, once they are more likely to be arrested a second or third time, not because they've necessarily done anything more than anyone else has, but because they've been arrested once or twice beforehand. And then it's marked and underscored Anna Mary Barry Jazer. You'll have to, I'm not going to butcher those names, Ben Castleman and Diana Goldstein, Marshall Project. You'll have to click on that and go research that yourself. All of this is very interesting, and this is coming about. This is how what's going to decide what happens to us if you're arrested. And as many of us know, you don't have to do anything wrong to be arrested. There are other problems embedded in the choice of stats. Risk assessment often uses failure to appear rates to predict someone's likelihood of returning to court, but most people who miss court aren't intentionally dodging an appointment. They may be homeless, have child care issues, or have simply forgotten. Using this data to predict whether someone will abscond yields misleading futures. And here's another link that you can go on to check that out. Similarly, an arrest on its own doesn't necessarily mean a person reoffended. Although arrest and convictions are an imperfect measure of actual criminal offending, they are used, as it were, on both sides of the equation. That is, nearly any model meant to predict recidivism will also use arrest both as a predictor as well as a thing to be predicted. As a recent paper from the All Now Institute argues, in the retailed context of predictive policing, building predictive models with data about policing risks laundering that data, turning it from a description of what has happened in the past to an algorithmic plan of what should happen in the future. As long as the arrests are fed into a risk assessment, the same danger applies. And then there's some more research to back that claim up. Each context in which a risk assessment is used to raise unique data questions. Risk assessments are used at many stages of the criminal legal process, from bail to sentencing to parole determinations. And measuring risk means different things in each of those stages. For instance, the likelihood that a person will show up to court is irrelevant to the risk assessment tool used to inform parole decisions, but it is of course essential in per tail risk assessments. By some token, a sentencing risk assessment that predicts the likelihood of rearrest within 2 years would not be especially useful in the short-term horizon required for a pre-tail tool. Despite this, risk assessment tools are often put to use other than that for those for which they were designed. For instance, Compass was initially developed as a software to help corrections departments manage cases. Yet today, it is commonly used in other contexts, such as sentencing. All of this is just to say that developers of risk assessment tools must consider the province of which the data they use to train their models, lest they perpetuate the flaws of existing policing strategies while ensuring them in a veneer of mathematical inevitability. Similarly, consumers of risk assessment tools need to know about the choices and tools developers make and to be aware both of the limitations in the data as well as the broader social context in which the data is created. All algorithmic risk assessments based are algorithmic risk assessments biased. The question of bias in risk assessment captured headlines in 2016 when ProPublica published an article subtitled, "There's software used across the country to predict future criminals, and it is biased against blacks." The author of the study thoroughly analyzed the applications of Compass at sentencing of courts in Broward County, Florida. The analytics showed a racial disparity in false positives and false negative rates, meaning that people in the algorithm determined to be high risk, but who were not rearrested within 2 years, were more likely to be black. Similarly, those who Compass labeled low risk, but did have a new arrest within 2 years, were more likely to be white. So ProPublica's fairness metric looked like backwards to see what algorithmic got right and wrong, and then compared to the error rate across the state or across races. North Point, now called Equivalent, the company that developed Compass, defended the tool, arguing that Compass was not biased because white people with high risk scores were about as likely as black people with high risk scores to be rearrested. But North Point's notion of fairness missed something. Black and white people in Broward County and elsewhere are arrested at disparate rates. In part due to biased policing, so black people are more likely to have arrests on their records in algorithmic that predicates the likelihood of reoffending based on arrest records, perpetuates those same racial disparities. Crime rates are a manifestation of deeper forces. University of Georgia Law Professor Sander Meissen said, "Racial variances in crime rates, where it exists, manifests the enduring social and economic inequality that centuries of racial oppression have produced. Codifying those historically inadequate into algorithms may drive more incarceration, further compounding generations of discrimination." The question of whether North Point's approach can still be fair is one for policymakers and ultimately for the communities whose values those policymakers represent. The potential public safety impact of false negatives will likely be... Oh, shoot. It looks like I had a Facebook's friends request, huh? The potential public safety impact of false negatives will likely be prominent in such discussions, for false positive deserved as much more attention. In the potential context, a false positive may mean a person's losing a job while being detained unnecessarily, or even made it more likely for that person to be ultimately convicted. For sentencing or parole determinations, false positives may lead to substantially longer periods of incarceration and more time away from their families and communities. The extent to which false positives destabilize the lives of the people affected in the potential criminogenic impact of the destabilization should not be discounted. It is also worth noting that bias may go undetected due to business interests of companies such as Northpoint, which refuse to fully disclose its methods at the risk of losing a competitive advantage. The problem of interpretation. One of the main arguments proponents of risk assessments put forward is that even if there are some bias in algorithms, that bias can be observed, studied, and corrected in ways that human bias cannot. In practice, however, the interplay between algorithmic and human decision-making is complicated and sometimes leads to worse outcomes than either a human or computer deciding alone. Kentucky's experience with risk assessment shows some of the complexities involved with the human algorithmic judgment interact. In 2013, the Commonwealth rolled out the Arnold Foundation's Public Safety Assessment, PSA, with the express goal of lowering pretrial detention rates. Pretrial. I think I've been saying that wrong the whole thing. Oh well. Lowering pretrial detention rates. Implementation of the tool came with statutory presumptions of release on non-monetary conditions for low and moderate risk defendants. However, an analysis by George Mason, University law professor Megan Stevenson, of bail decisions in Kentucky in the risk assessment area demonstrated several troubling findings. For one, racial disparities in pretrial release rates increased after the algorithm was adopted, largely due to the fact that judges are largely white. Rural areas increased their release rates at a higher rate than judges in more diverse non-rural areas. Further, Stevenson's analysis showed that early gains in decarceration due to the tool were short-lived. Immediately following, excuse the interruption again. Immediately following PSA's rollout, the potential detention rate in Kentucky plummeted, with 63% low risk defendants granted some form of non-monetary release. Moderate risk individuals fared similarly. However, even after the dramatic decline, Kentucky still has a pretrial detention rate above the national average. While better technology has the potential to make risk assessments fairer, that result is far from guaranteed. California has also had a troubling history with pretrial risk assessments, also largely due to the judge's selective application of the tools. Recommendations, for instance, Human Rights Watch reported that Santa Cruz County judges agreed with 84% of the detained recommendations, but just 47% of releases. Recommendations similarly, Alameda County judges set bail in 3/4 of the defendants labeled low risk. What accounts for these judges' tendency to disproportionately override risk determinations that would have been favorable for the defendants or the accused? One recent study suggests that poverty may interact with risk scores in the sentencing context to produce harsher sentences for the economically disadvantaged. More than 300 judges participated in the controlled experiment in which they were given vagentas describing defendants differing only in socio-economic status, relatively poor versus relatively affluent, and whether risk assessment information was provided. The judges were asked whether they would sentence the person to probation or incarceration. The study found that the judges who received risk assessment information were 15 percentage points less likely to incarcerate an affluent defendant than those who did not see a risk assessment score, or see a risk score, Conversely, my Facebook is blowing up. Conversely, presenting risk information about a relatively poor defendant was associated with a 15% point increase in likelihood of incarceration. The very way in which risk assessment results are presented to judges may affect how they use those reports in their bail or sentence determinations. Most risk assessment tools, rather than presenting numerical risk scores, present described subjects as being low, medium, or high risk. For instance, the pretrial risk assessment, PTRA, used in the federal court system characterizes subjects as having a risk level between 1 and 5. Intuitively, one might think that each of these risk levels correspond to 20 percentage points on the risk scale, such that those at level 1 risk are in the range of 1 to 20% likely to violate conditions of pretrial release, and that someone at level 5 is nearly certain to violate at between 80 and 100%. And here's a little chart, and like I said, there'll be a link in the description, and you'll have to go through some of this if you're interested. And there's lots of links in this article, and a lot of information that it's worth checking into. In fact, fewer than 20% of those in the highest risk group, according to the PTRA, will violate conditions of release by being charged with a new offense. A judge relying on the intuitive interpretation of those scores will dramatically overestimate not just the actual risk such a person may pose, but even just the output of the tool itself. There is some evidence to the suggestion that taking human judgment out of the risk assessment process entirely could prove better outcomes. A computer simulating use of a model trained on 5 years of New York City arrest data showed that replacing human judgment on bail decisions with a risk assessment tool could reduce pretrial incarceration by 40% without affecting crime rates. In some versions of the model, the researchers were able to weed out some of the racial bias by ensuring that the number of jail defendants of a certain race could not be higher than the percentage of defendants of that race. Other research suggests that machine learning algorithms can outperform human judges in determining the likelihood of an accused person failing to appear in court, that even much simpler algorithms perform nearly as well as the more complex machine learning models on this task. Conversely, a recent study found that untrained lay people recruited through Amazon's Mechanical Turk performed comparably to Compass at predicting recidivism risk. However, critics claim that methodological I can't get it out, flaws call these results into question. None of this is meant to suggest that computers should have sole discretion in bail or sentencing decisions. Not only is it extremely unlikely that any jurisdiction would take humans out of the loop entirely, if such a scenario were even desirable, but as one state's Supreme Court found, doing so could even violate the constitutional right to due process. Algorithms go to court, the Loomis case. In 2016, got another Facebook. They're blowing me up. Algorithms go to court, the Loomis case. In 2016, case State versus Loomis, the Wisconsin Supreme Court became the highest court to squarely address constitutional questions around risk assessment. Eric Loomis pled guilty to several charges stemming from a 2013 drive-by shooting. The trial court then conducted a pre-sentence investigation that included a Compass risk assessment. Loomis was determined to be high risk across all of the dimensions of the Compass, purports to measure. He received a split sentence where he would have to serve at least 6 years in prison with a substantial period of supervision thereafter. Loomis then filed a post-conviction motion challenging his sentence on the grounds that the use of Compass violated his right to due process, among other challenges that are not related to risk assessment. This challenge ultimately made its way to the state's high court. Loomis had several objections to how Compass was used in his case. For one thing, he claimed he was unable to effectively challenge his risk score because of the closed, proprietary nature of the tool, and that this violated his right to be sentenced based on accurate information. The court was not troubled by this use of a black box model, finding that Loomis's due process rights were satisfied by his ability to challenge the accuracy of the facts and were fed into the model, as well as the present evidence that the risk scores Compass generated were incorrect as they applied to him. the court found that the risk assessment was not itself determinative of Loomis's punishment and was just one piece of the information among many. State versus Loomis. While the court ultimately declined to grant Loomis relief, it did take the opportunity to articulate a set of disclaimers that must accompany risk assessment reports going forward, each of which raises important considerations for the court's using algorithms to punish. First, the court mandated that proprietary risk assessment tools note when they do not disclose the risk factors they use or the weights assigned to them. So while the court did not find that the use of secret algorithms impinged on Loomis's rights, it nonetheless determines that Wisconsin judges ought to keep the opaque nature of those tools in mind when they use them at sentencing. Second, the court required that risk assessment reports come with caveats when the tools used to create them have not been subjected to validation. Studies that verified their models' predictions against the local populations. This problem is not unique to Wisconsin. Most states use risk assessments, do not have such studies. Those that do not have made their results available. Okay. The court required further that reports acknowledge concerns about racial bias of the kind discussed above. Courts will undoubtedly return to this issue with increasing frequency as the tools become ubiquitous. Just as courts need to be confident that risk assessments are correct with the respect to the residents of their communities, they must ensure that the tools remain accurate over time. The failure to do so could result in so-called zombie predictions that may artificially overstate risk due to outdated data. The court's fourth admission explains just the risk. The court's final label warns of the dangers of applying risk assessment tools to different contexts than those for which they were designed, such as using recidivism tools to predict the risk of failure to appear. Some critics have dismissed the Loomis court-mandated disclaimer as window dressing. Indeed, the court have gone further in the actual addressing some of the shortcomings it observed rather than just requiring they be pointed out to judges going forward. However, if other courts are considering risk assessment show the same willingness to engage with the subject as Wisconsin's High Court, there is room for optimism. Conclusion. The use of algorithmic risk assessments has exploded in recent years, and despite the efforts of organizers who are opposed to the tools, this trend seems unlikely to abate anytime soon. The technology is sure to become more sophisticated as well, which would lead to even less transparency as today's relatively simple, interpretable models are supplanted by powerful but opaque deep learning methods. While better technology has the potential to make risk assessment fairer, the result is far from guaranteed. And it is up to the people who design, implement, and employ these tools to ensure they do so in ways that reflect the values of their communities and safeguard the rights of those that society margins. So, I think this stuff is kind of scary. I mean, there's so much room for error in here. And But then at the same time, there's lots of error going on right now. I mean, we have judges that use prejudice, whether it's racial or against a certain person or a certain crime. Uh, I guess maybe there is no perfect system, but I think we should kind of use both. Uh, I know judges have a lot of power, and we have a lot of judges that just think they are above everything. Uh, I don't think. I think there is a large number of judges who, because of their position of power, ultimate power corrupts, and they think the world revolves around them, and in their little circle it does. Otto the watchdog is in jail for flipping a judge off. He's been there for a month. That's the Supreme Court has ruled that as freedom of speech, haven't they? So, because he pissed that judge off, that judge took 30 days of his life, and he put him in a dangerous place. He incarcerated him. There's people that are in there for murdering people and other crimes that Otto is not into doing. He's not a danger. He's a pain in their ass is what he is, because he wants to be, because he's tired of their shit. But anyway, just a shout out to Otto. He should be out any day now. Can't wait to see him. I miss him. Not that I really know him, just got used to seeing him around on YouTube. And I think I'll wrap it up with that. What do you guys have to think about it? Do you think algorithms are better or worse? What about the people that this stuff is being tested on? What happens when they find out in 10 years that every third person was sentenced wrong? Kind of like with DNA, or kind of like when DNA came around also, right? They DNA set a lot of people free, but they're also finding out that there's some things about DNA that they were doing wrong. So any new process needs to be thoroughly examined and debugged before they use it, not 10 years after. But with that, I'm going to sign off, and looking forward to hearing your comments. If you've made it this far, don't forget there'll be a link in the description. There's a lot of information in here, as well as the other article by this same appeal that I read. There's other information to research, and I would strongly suggest you guys do that. Keep yourself educated and knowledgeable on what's going on today. So like and subscribe if you haven't already, and hope everyone had a good weekend. I'm out of here.